transition to the regulatory session now. So, you know, talking about privacy and personal information and the personal data. So we now have a panel discussion with three privacy experts or business and privacy experts, let's say. So I'm happy to invite on stage Jana Moser, Kostas Rossoglou, and I think Jürgen is going to be mic'd up, so we might wait for Jürgen to join us. So please join us on stage. So Jana has been, she's an expert in data and privacy. She's going to drive us through a bunch of information in the new, let's say, dilemma and challenges that privacy is raising, regulatory-wise, and how do you cope with innovation, data, and privacy. Kostas is the head of public policy EMEA at Yelp. He's been dealing with personal information, data, and privacy, and a bunch of other EU issues for a long time. And Jürgen Weichert is a brand new Siinda member, so glad to underline that. Working at Usercentrics, and they are one of the leaders in the user control management on the planet. So, Jana, floor is yours.
Thank you very much. So first of all, thank you guys that you're still here. I know it's pretty late already on this day, and I guess most of you are a bit tired, and now a pretty tough topic when it comes to privacy, of course. But I'd like to make it short because we have two more presentations on the topic, and I'd like to give you my opinion when it comes to privacy and innovation and how you can combine those two topics somehow. So first of all, we talked about a lot today about artificial intelligence, big data, smart data, and all the trends we hear a lot being now, health and well-being as a subject as well, and of course, privacy. Because privacy is one of the biggest topics at the moment, especially when you talk about innovation. Most of you, and who think about privacy and innovation especially, and when you talk about innovations and new ideas and maybe how you can pivot your business model, it's most of the time it says, oh, we can't do it for privacy reasons. But I think actually you can do a lot of things when it comes to innovation and digitization. And your business area is very much in the need to change maybe the business model or how to target especially the clients. So when you talk about the challenges of innovation, most of the time you have a lot of data. You collect a lot of data, and in the end, it's all about compliance, because if you can't use the data, it's not worth anything at all. And on the other hand, you have your interests as a company, as a businessman, of course, and a business owner maybe, and on the other hand, the consumer interests. And you have to find the balance in between of it. On the other hand, you have the technical feasibility, and you know you can do a lot of things. If you talk, for example, about blockchain and all this similar technology, you think, wow, we are capable of a lot of things. But is it really helpful for the daily need and the daily life, especially of a consumer? I'm not quite sure, and you should think about it as well. And last but not least, you have on the one hand the regulation, and on the other hand it's omnipotent. So the technology is omnipotent. You can do almost everything. But the regulatory side, on the other hand, will make it impossible for you to really implement it if you don't care for the regulation. So what impact actually has the regulation on your business when you talk about innovation and maybe digitization? On the one hand, it's of course privacy by design and by default. We heard in the last presentation about it, that she said, okay, we implemented it right from the beginning, or at least we assessed it thoroughly, because we know when it comes to health data, patients' data, it's very important that we comply with the law. When it comes to digital online businesses, especially advertisement, we have the issue with third parties. Most of you implement third-party technologies. So you have third-party or data transferred to third parties, and then you have to inform the users about it and your customers. And you have new obligations, especially when it comes to information, and maybe to sign specific documents like data processing agreements, etc. And in the future, and that's one of the major topics at the moment when it comes to either e-privacy regulation, maybe you have to inform about data transfer, data processing, even if it's non-PII, so that means non-personal identifiable information, machine data, Internet of Things, and all this stuff. So the solution from my perspective, because I worked as a legal counsel at Axel Springer in the past, as a manager, and as a data protection officer on one of Germany's biggest competitors of Facebook, StudiVZ, in the past. These are my solutions, or at least my opinion. On the one hand, privacy by design is a must-have. You can't avoid a privacy by design. Now it's set forth in Article 25 GDPR. Additionally, some people talk about privacy as a USP. From my perspective, and we can discuss about it, of course, privacy can't be a USP. You have to comply with privacy, yes, but you can't really make any advertisement with, oh, I comply with privacy, because it's your obligation, right? It's, you can't do any advertisement with that you comply with tax law. That's simply your obligation. If you overperform, we can talk about it, but not just because you comply with GDPR, for example. So from my perspective, consumers and customers look for convenience and not for privacy. The third point is that most companies, like you, for example, have the core business. Concentrate and focus on your core business and cooperate with others who use privacy or other compliance services as their core business. You don't have to focus on it. You don't have to invent a new privacy system, invent a new compliance service, whatever it is, for example, when it comes to consent management, data management, etc. But trust other companies whose core business that is. And last but not least, focus on corporations. You won't survive as a single company, from my perspective, if you really want to work with data, if you really think your data is your exclusive ownership and you must be in control of your data when it comes to consumer data. So these are my opinion on data and privacy and innovation, how you can combine with it. And I'm pretty sure one of the next presentations will add up very, very good to it. Thank you very much.
Thanks very much, Jana. Kostas, do you want to step on? We're going to do some panel discussion afterwards. So we, on purpose, coordinated the session as, another moderator underline. And we're having some short presentations and then discussions in the end, so you can all also throw in your questions. Kostas?
So it's also my pleasure to be here. And I would like to go a step back because we've been talking the whole day about how we deal with data. There is a problem with compliance. How can we reconcile technology, AI, and the data protection privacy regulations? But it's also important to take a step back and look like what's happening, how do we get there? And this is something that is not always in the mind of people like you working with a business. You just have to comply with laws. But it's also important to engage before the laws are actually being adopted. And just to give you a bit of background where we stand now, some of us are working in Brussels and we have to work with the European institutions. These are the institutions who have adopted the GDPR, who are currently discussing about the e-privacy. And it's interesting times because we have a new European Commission, we have a new European Parliament, and we also have competencies being merged. For the first time, we'll have a competition commissioner who has a very keen interest on data, and she's going to be the enforcer, but also the regulator, because she's going to be in charge of tech regulations. So it's a very unique position that she will be, and she has a lot of power. And of course, in the European Parliament, the e-privacy regulation is in the process of being discussed, and we still don't know what will happen. So these are some of the issues that are currently pending. The e-privacy regulation, I think you all have an interest in that. The GDPR enforcement, GDPR has been adopted, but now we're waiting for the Data Protection Authority to start enforcing the law. There's a whole discussion about competition law, whether data should be considered when assessing the market power of a company. Digital Services Act about the liability of intermediary service providers. Are companies like Yelp, for example, liable for the content that's being posted on Yelp? Are we obliged to proactively take down reviews that might be considered defamatory even before we receive a notice or a complaint? So these are all important questions. And then at the same time, I always call it like the jurisdiction wars, because we have the EU as a bloc, then we have some national countries, member states, but then we have the US, we have China, and then when it comes to data protection, interesting times, because a couple of years ago we had the GDPR, and the Americans were saying we will never have privacy regulation in the US, but now we have the California Consumer Privacy Act that will enter into force, and there's an overlap. A company like Yelp, which has to operate in different jurisdictions, when we talk about compliance costs, they increase simply because we have to find our way through the different regulations, and that might not always be on the same page. I have on the slide, you can see some of the overlap and some of the differences between the California Consumer Privacy Act and GDPR when it comes to the scope, the obligations. For example, there's no obligation to appoint a data protection officer in the California Act. We have that in GDPR. At the same time, we have the European Court of Justice, who is becoming more and more active, and I call it that judicial activism. We had like two very important rulings very recently, the last month, which had to deal with the territorial scope of European legislation. One was about the right to be forgotten, right to be delisted, and whether Google should be responsible to take down content globally or only within Europe. And the other is a Facebook content moderation decision, where the court again said that Facebook might be obliged to remove a defamatory comment worldwide and not only within the EU. And then within the EU, we've been talking about this the whole day, GDPR versus artificial intelligence. How can we find our way? Of course, every company needs to comply, and every company wants to comply with the law. It's a legal obligation. But what is also the role of policymakers, regulators in facilitating companies' compliance? We have also the overlap and the potential conflict between data protection and freedom of information. Do we need to take more and more content down proactively? What's the impact on free speech? This is a general question about liability of intermediaries and the fundamental rights of users. It's a very delicate balance, and these are going to be issues that are going to be debated in Brussels for the next 5 years, and it's important to be involved. So I'll leave it there, and I'm sure we'll get back to some of those issues during the discussion.
Thanks, Kostas. I mean, so we're going to talk later on about the whole thing, but one of the recurring point is definitely consent, and how because consent is definitely something you have to comply with no matter where you are in the value chain. And how do you cope with user consent management? This is one of the tricky parts. And Jana, you said very thoroughly that don't try to do stuff that you're not specialist into, and you can partner with some people whose core business is privacy. So, Jürgen, I think you're going to talk to us about user consent management as your specialty.
Absolutely, Stephanie. Thank you very much. Hi, my name is Jürgen. The one other person in the room knows me. I'm with Usercentrics, and we are a market-leading provider of consent management platform, which means a programmatic way of getting user consent. And how we view this business is not only about being compliant. Jana mentioned that it's just an obligation. It's not a feature, a USP. But what compliance allows you to do is actually to provide data-driven business models. So I have a quick question. Who of you considers him or herself to work on or have a data-driven business model? There are a few hands. I would like to see more in order to actually have a nice, successful Siinda membership as a newbie. But maybe some people are shy or just don't listen to this bald guy with a beard on the stage, which is totally understandable.
Ask the question at the bar tonight, and you might get some different.
Absolutely. So data-driven business models are super important. Regulation is a framework. And I would like to start with a quiz. So all of you can read this. Europe raised the bar. GDPR is great. CCPA is coming up, as Costa mentioned. So we should have a federal law in the United States. Who do you think said that? Mark Zuckerberg? Mark Zuckerberg? Well, not quite. Actually, my former boss, Sundar Pichai, so close, but almost. Very, very interesting that user consent, well, a global regulation of user consent is, of course, in the interest of big tech companies. And why is that? I mean, why do they even care about it? And I think there are three colors in terms of why this is important for tech companies and why this is important for us here in this room. So first of all, governments all over the world have one regulatory trend. Personal data can only be used with consent. That's first in the EU, then at the moment in the United States with California, but also other states like Texas, Maine, even Nevada, where everything else is probably legal. Consent is required and privacy laws are enacted. India, Brazil, Japan. So it's a global regulation trend, and I hate speaking about fines because we are not the GDPR, we are not a regulation. We help companies deal with this. However, there are, of course, serious fines in terms of 4% GDPR. Everybody knows that, 4% of the revenue. CCPA is interesting because they work with fines of $2,500 per incident per user, which can become actually quite high amounts if you calculate with high traffic sites or even relatively low traffic sites. So there are fines, but even more important, there are tech companies like Google and Facebook who operate on the market and who require consent for personalized marketing like remarketing, which is very important for the SMBs and also, of course, also the companies in this room. And my conclusion here on this slide is, in order to make dollars with data, you need consent, period. How do we help? So no personalized marketing without consent unless you use a consent management platform. We are specialized in that. That's all we do every single day. I know it sounds boring to you guys. I love it. So what we do is we collect the consent, we process it, document it, and make sure that the platforms behind it actually follow also this consent, if it's a yes or a no. And that makes sure that your clients actually get the consents of their users, which is a data treasure. We are speaking of data treasure because personal data is worth money. We are speaking with, we have deals with US companies that actually want to offer users Amazon vouchers for giving consent. That's how much they value these users' data. So we're coming to the data economy through the back door of privacy, which is certainly very interesting. Not surprising to me. My background is that I spent the last 6.5 years at Google, in Kartik's team, actually, who spoke earlier this morning. So data is a little bit, of course, the data is valuable, is a given. And all in all, the message we convey to our clients is to view consent as an opportunity, privacy as an opportunity, because if you ask, what is the basis of all business? I would like to ask this question to you. Exactly, I hear trust. Trust is very important. There's a link to a Harvard study, which will be shared within this presentation, that says that trust and open communication about data and how websites handle data increase conversion rates, increase revenues. The number I copied from the Harvard report with 38% I find very high, but that's probably how the study is conducted. I would recommend reading through it because all in all, the message is clear. In the long term, revenues can rise if user trust is there. And what we see as actually having worked on this consent management for over 1.5 years now, one of the things we see is really most users actually do consent. So it's not like companies would lose all data, but they win clean data. And at the end, this is the data treasure I've been speaking about to build a data-driven business. Thank you.
Thank you, everybody. So I'm going to open the floor for questions, but I think, yeah, okay. I was going to ask if Christian, you had a question, so.
Hello, very informative. So one of the questions I've spoken to at least one of you about is it's very hard for many of these companies that are doing tech transformations to get your type of expertise in early stages of product development. What advice would you have to help bring the lawyers, the experts into the room? Because it takes a lot of time to change a product once it's halfway baked. And yet, if they're not thinking about it early, how do you get people to engage from a product perspective as they're building products with legal compliance and even third-party vendors to do the right thing from the beginning?
Probably we would say hire us, but you know. I mean, seriously, I think this is the data protection by design aspect that we were talking about before, and it's starting to spread in the big companies, in the big tech companies, and we see that happening also with all the AI discussions at the moment, and also the data minimization that you spoke about yesterday in your insightful presentation. The fact that data is starting to be seen not only as a commodity in the sense that has been talked about, but also as a user propriety. And so this is a trade-off in the end, right? How much are you ready to give up or to exchange for how much personalized services? And this is really started to spread into boardrooms. The problem that you mentioned is that it's very difficult to breach the level of regulatory expertise and jargon comprehension that you need to be able to talk to those guys in Brussels or in Washington or wherever to make them understand that the way they shape the laws can have some resonant effects not only on the business but on the user in the end, and the way discussions are taking place in the boardrooms when you design a new product. So, you know, the example, for example, of the previous presentation with all the platforms and so on, to me, the first question was, what about PII? You know, if you have a problem with PII at the beginning, then the product might not be that easy to sell. If PII is dealt with very well, then it's fine.
Maybe I can refer to that question too, because I think it's a very good question, which made me think first. And I thought about, okay, how do we do that at Usercentrics? And what we do is, of course, we have privacy experts in our company. We should have, right? It's our core business. But what we did is we did a train the trainer concept to actually train everybody that's involved somehow in the product, be it customer success, be it development, be it product management, in the principles of data protection and privacy. As I said, it's our business. And one recommendation I could give is data minimalism, of course, already minimalizes the risk of PII being in the product at a too high extent. One of the things I would see when I joined the company, I saw that the team has done that right. to work with the right experts in the beginning, to get the know-how inside by train the trainer concepts, and to not go to, let's say, the lawyer who's behind the boonies and who's heard of some privacy regulations because he read an article, but to rather invest in really high-intensity sessions with real domain experts. There are always a few lawyers, and not only lawyers, but also privacy experts who help you put this in practice, and use these sessions really intensely to get know-how internally, and then to spread it in a more digestible format throughout the team. Not everybody has to be a privacy expert who can discuss with Brussels regulators, but to understand the basic principles is something which is very useful in this day and age for everybody's future career.
Yeah, of course. I mean, it's more or less my domain. So because I worked as a lawyer internally, for me, I know how difficult it is to be involved, especially when it's a big company. If you have different departments, usually they compete with each other. They try, of course, to make the best product on the one hand. On the other hand, they have their own goals. They're measuring, actually. And from my perspective, as you already said, is try to implement it as early as possible. And we discussed about it earlier outside the room. The point is you have to translate sometimes the different regulatory requirements to a business level. And that's what legals usually can't do. It's not that they are not interested in it, but their focus is a different one. If you ask, for example, a data scientist about marketing, they said, I'm sorry, I'm not interested. That's pretty fine, but you have to bring everybody on one table and to discuss this topic from different angles. And I think that's a cultural thing in a company as well. So try to start with the pain points right at the beginning and the different perspectives on a product. If it's a regulatory perspective, it's a marketing perspective, a sales perspective, doesn't really matter. But the privacy perspective is a must-have at the moment, especially when it comes to privacy by design or by default. And so I think it's a big, big mistake to start this discussion too late. So bringing them on the table, as you already said, try to set the mindset in the right direction, involve the right people, and then you can avoid especially the very, very expensive lawyer at the end if you start right at the beginning and you have the right mindset at the beginning.
I want to shift to a slightly different topic in terms of what the user experience is. So I've been struck in a couple of trips to Europe recently by the wide variation in notifications that you get. Some of them look like accept all and link to manage cookies, and some of them are more progressive in terms of your ability to and accessible. So there's and you click through and you get lots of screens and scrolling and lots of categories of cookies, and it puts an enormous burden on the end user. And I find a lot of publishers are really trying to bias the outcome by getting people to accept all cookies. So this, to me, is where the practical application of GDPR and ultimately CCPA will come into effect, is how easy is it for the user to understand and take action on these principles? Do you have any comments on that?
I think you touched on a really, really good point, so thank you for that. I believe that Usercentrics is called as it is called for a certain reason. There's always a triangle between the user, the company, and compliance. And in reality, in order to meet business needs, users' needs, and compliance needs, you need to find the middle ground. So what you described is, of course, the very, very granular, very detailed overview over 300 pages of information, which may overload the user, versus the other extreme to say, please just say yes, and the no button would actually move away from the mouse. Both extremes are not cool because they're not good for the user, and they certainly are attempts of trying to find space in a place where court decisions have not been there yet. Since the 1st of October, where the EU Court of Justice said that there has to be a clear opt-in, Some things have been clearer. There are still a lot of uncertainties because we have a lot of regulators in Europe. We have 28 countries still to this point. And alone in Germany, we have 17 data protection regulators in 16 states. So there's a lot of complexity. One thing we do is actually we do recommend our clients certain solutions without giving legal advice, but more from the user experience perspective. And we offer A/B testings to make sure that you get a good user experience that actually drives the user through to the site, at the same time being compliant. There's not the easy answer, unfortunately, to say it has to be this and that way. But we recommend our customers not to go the extreme ways of clicking a big yes and as an alternative, a small yes, and no, or like the 300 pages of data that nobody understands. We try to structure our product that way, and it's a permanent, ongoing thing, and software as a service product is never done. So we are permanently optimizing the UX, and that's why I think, to Stephanie's point, working with domain experts may make sense, because that's what we're doing all day and nothing else. The out-of-the-box solution is not there, unfortunately.
We're getting a bit late. Thomas, you can have the last question, and then we're all going to be around, for dinner, so you can have some questions also directly to Jana, Kostas.
Thank you very much. I would like to shift to the user's position, and we are in a business too where we have to, of course, follow the cookie consent regulation. And in our experience is that, for one thing, well, probably that's natural, lots of users are annoyed by the thing, especially security, users that follow security rules like deleting all their cookies when they close their browser because they get the same questions every time when they visit a website. And on the other hand, there are users who install plugins that just do that stuff for them. They don't see the cookie banners anymore at all. So what I would like to ask whether, I know nobody of you made the regulations, so we're all on that side. But whether this is not probably a solution that doesn't work at all, because if I browse the web and I would have to read all the content I do visiting websites, I would do nothing else anymore. So what do users do? They just accept and probably not actually knowing what they accept. So probably from the user's point of view, it's not really any help in terms of privacy regulations or anything else like that.
If I may comment on this, it's actually exactly my concern to say that there's this overload of cookie banners, most of them actually not doing anything. So study of the Ruhr-Universität Bochum and University of Michigan of Detroit said that 87% of all websites in Europe are not compliant in terms of notifications. So that said, you get ugly banners and you don't get data protection. So that's really like the worst of all games. Two points. One is make it as easy as possible. This is what we thrive for. The second is the best cookie banner is a cookie banner that is not shown. May sound strange coming from somebody like me, but our software, for example, makes sure that the cookie banner display is only to the absolute necessary minimal and does not have to come up again. There are other ways for the user to actually get access to his cookie settings through the website if they want to. If they don't want to, they shouldn't be annoyed, because this doesn't help the cause. If users are just annoyed and automatically click, the quality of the answers will be bad.
If I may add two things. On the one hand, as you already said, it's very difficult to read everything. But privacy is also the right to be informed. So that's not that you have to, but in the end, it's that you have the freedom to read it. So it's like the right to go to an election, right? You don't have to go to, but it's your right to do it. That's on the one hand, so that's the reason why I still feel like a privacy lawyer or someone who is actually for privacy. I'm not against it, although I'm not a privacy lawyer anymore. But on the other hand, there are some very, very huge misunderstandings, especially you mentioned already the last ruling. It does not. Didn't say you always need a consent. That's a totally misunderstanding. It says in some cases you must have a consent from the user, obtain a consent. But on the other hand, there are other legal bases on which you can process data and use it, especially legitimate interests. And that's one of the biggest things that you say, okay, do I have a legitimate interest to process this data? Yes or no, and then I have to inform the user about it. If you're not interested in it, okay, then you don't have to read it. I totally agree with you that the topics and the texts are too long and that they overdo it sometimes. I totally agree with you, and that especially some regulation is simply too much, it's overregulated. And that if we don't really care about it, how we do our businesses, they will overregulate it even more. Because we collect data, and then we think we want to do everything with this data, and in the end, we don't really do something with it, but nevertheless, we have to inform it about it. So you already talked about the limitation of data storage, etc. And that's the topic. It's sometimes we complain about it from a business perspective, but we don't really do something for it. That means to really shape what we do with data, the data strategy. We all want to do something with data, but we don't have really a strategy. And that's the reason why we have something like GDPR with, I don't know, 500 pages of privacy policy.
If you look at it in day-to-day life, it's probably not that difficult, right? Because even if I'm interested, and I would want to read all that stuff, that's one thing, that's just not the time for it. And the second thing is many people just don't understand.
But the point is that GDPR won't change it. GDPR is there, and I'm pretty sure it won't change it.
I know that the point is there, but it doesn't help the user in very many cases.
Right.
It's a theoretical thing, and in the end, if I accept something I don't understand, or I just click consent just because I can't take it anymore because each and other website asks for it. So in the end, I consent to something where the business in the aftermath says, well, you accepted it. What's your point?
Right, and that's in the end, that's what the outcome of it, of the demand of more consent, and the companies who are strengthened are the big ones, the monopolies, who already have the consent.
That's a really, really strong point.
The companies that are hit will be the small ones.
Right, that's absolutely true. The politician didn't understand it.
That's a really, really strong point you made there, and I think, yes, we have to make it easier to understand. That's one side, and because there's the right to be informed, and I think to make it easier actually speaks for this right to be informed in an understandable way. And then there's, as a society and as an industry, I think it's very important that the general audience has to be educated on these topics, because digitization won't go away. This is really, really important. And the other thing is, of course, we have to be able to take consent and use data in a data strategy, because otherwise the small businesses will not be able to compete against the big ones. So I think we are very much we're very much on one page there, because data is the oil of the 21st century, people said. I think that's just BS, because data is just data. Insight is important, and insight you can only get if you have consent and if you follow these rules. And of course, it's a permanent project to work on this to make it easier for companies, and we're here to partner with you on trying to make it easier for SMBs.
Yeah, and I think as a final word, I think it's also part of Siinda mission statement to have these kind of discussions and facilitate also the discussions about the implications of privacy, and try to bridge, the expectations of the data tech development. But as you said, also to move away from the logging environment locked by the big companies and enable the small businesses who are your partner to be able to also enter the game. So this is one of the big push where Siinda is also active for as a trade association. So, yeah, thank you very much. Thank you to all of you.